As your case gets close to trial, now, is it better to try and negotiate with the judge involved in the settlement discussions, or is it better for the two attorneys to get together, pick up the phone, and try and negotiate your case by themselves? You want to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is going to depend on whether there is trust, mutual trust and respect between the two attorneys on your case. Now, what do I mean? If your attorney and the defense attorney have worked together in the past and have successfully settled cases before, typically then, there is a level of respect that occurs between both lawyers. In that instance, it may be possible, in fact, it may be more likely, that now the two attorneys can try and negotiate this case before ever getting to trial, because there is already an established mutual level of trust and mutual respect between the two attorneys. Now, don't think just because there may be a mutual level of respect that one attorney is giving up something because he's friendly with the other lawyer. No, that's not how it works. Each side vigorously represents their position. But if there is respect and trust between the two attorneys, now it becomes much easier to have a settlement conversation just between the attorneys. Now, contrast that scenario with a case where the attorneys have never worked together before. They don't know the reputations of each other. They don't know anybody who's worked with these attorneys before. So now when it comes time to possibly trying to negotiate this case, even though the defense attorney may have been given authority and given permission and given money to try and negotiate the case, the defense lawyer may be overly concerned that anything that takes place during negotiation may be misconstrued, maybe something is going to be misapprehended by the opposing attorney. And now, once there are misunderstandings, then finger pointing occurs, and now settlement discussions break down. So, in all likelihood, if that's the case, one of the attorneys or both of the attorneys will turn around and say, you know what, we would like to have settlement discussions, however, we would like the judge to be involved. We want the judge to act as an intermediary to see, in reality, to see if he can put pressure on both sides. And that's exactly what the judge will do during a pretrial settlement conference. If the judge is aware that both sides are interested and willing to negotiate, now he will first ask the defense attorney if they have money to offer, assuming, of course, we have made a settlement demand. If we have made a settlement demand, and if the defense has conferenced this case with their insurance company, with their principals, with their client, and now they do in fact have money to offer, but have not done so because of that trust factor is missing, that mistrust, now the judge gets involved and he will have separate discussions with each of the attorneys to try and gauge where each side is. Hey, where are you? How much do you have? How much are you willing to offer? And now he will come back to us and ask us the same thing. How much did you demand? How much are you willing to accept? What is this case really worth? After having these private, separate discussions with each of the attorneys, the judge will be in a better position to put pressure on both sides, to get them to come down off of their settlement positions, and now to see if he can get us closer to a mediated or a negotiated settlement that will avoid the need for all of us to go to trial. So, going back to the question I raised earlier at the beginning of this video, is it better to have a judge intervene and try and accomplish settlement negotiations? Or is it better for the two attorneys to pick up the phone and try and resolve this on their own? The answer all depends on whether or not there's trust. Why do I share this with you? I share this with you just to open your eyes to recognize what really happens in these medical malpractice cases in New York. You know, nobody talks about this, and I think it's so important for you to understand this as you're deciding whether or not to bring a lawsuit, whether you go forward with a case or not. And you know, I recognize you're watching this video because you have questions or concerns about your own matter. Well, if you're thinking about bringing a lawsuit but have not done so yet, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.